Good morning, and thank you for joining me on this webinar. My name is Phillip Kruger. I am a Regional Divisional Director at RSM South Africa in the Legal Department. In this session, we're going to be looking at the CIPC Compliance Checklist requirements as released by CIPC. So essentially, this is a list that requires you ticking yes, no, or not applicable to certain questions insofar as it relates to the Companies Act. But as you'll see during the course of the session this morning, it's much more complex than a mere tick and bash form. So looking at what we're going to be looking at this morning, just quickly going through the agenda, we're going to be doing a brief overview. So in other words, where does this requirement come from and what is the motivation behind it? We're going to be looking at applicability, in other words, who is bound by the requirements. We'll also look at what sections are included. Unfortunately, due to timing, this session is only 30 minutes. We'll only be looking at a brief overview. Then we'll be looking at what is actually required. And there I'm going to delve into a little bit more detail. I'll use section 4 of the compliance checklist questions as an example there. And then we'll also be looking at risks and consequences. And there particularly we'll be focusing on directors, as really that's where the buck stops in terms of this requirement. And then lastly, we'll look at some current uncertainties regarding the CIPC compliance checklist. In particular, we'll have a look at some comment from CIPC in that regard. So diving right in and starting with the overview, the CIPC compliance checklist is a compulsory item that must be submitted with your annual return from 1 January 2020. If you would like to have the authority for that, or if you'd like to keep that on file somewhere, it's Notice 52 of 2019. It came out a couple of months, I think it was a month or two before last year's end. So essentially, as I've said before, on this form, it'll pose a question. It'll say, did you comply with Section 4 of the Companies Act during the calendar year? And what is expected then is for you to tick either yes, no, or not applicable in answer to that question. But as we'll see, there's a lot to consider before you can actually exercise that choice. So what led to this? What was the motivation for CIPC to bring in these requirements? And really, it was numerous governance failures that we've seen. It was widely reported on in the papers, on television, in the news, and I don't think it's necessary to name names at this point in time. I think we all kind of know what happened in general in these scandals. But just looking back at the period of actually both 2018 and 2019, it was a very bad period for general corporate governance in South Africa. And therefore, you know, despite what one's personal feelings might be in terms of more compliance items and more red tape, looking at the extent of those governance failures, there might be merit in CIPC's decision to roll this out. So CIPC has stated, and they've gone on record to state, that the purpose of this exercise is twofold. One, it's to ensure compliance with mandatory sections of the Act. And secondly, they also say it's supposed to be an educational tool for directors in order to educate them on their duties and responsibilities. And there again, I think CIPC might have a point. As much as we still refer to the Companies Act of 2008 as the new act, you know, in truth, it was implemented in 2011, yet there are still numerous directors on boards that don't really have a handle on what their duties and responsibilities are. So again, there might be merit there. In my view, however, I think the main reason that CIPC is employing this is to monitor compliance. And in this regard, CIPC has also mentioned, and it's worth noting, that it will be not just public and listed entities that will be monitored here, though, but CIPC has confirmed they will monitor across the board. So all of this led to CIPC actively pursuing enforcement in respect of compliance, and as we said, that requires you to actually say yes, no, or not applicable, so positive or negative, either affirmation or confirmation there. And then what is in the list? Essentially, it's a detailed consideration requirement of 21 sections of the Companies Act, 2 regulations also included there, and of course for non-profit companies, Schedule 1 of the Companies Act also included in the CIPC Compliance Checklist. Looking at applicability, essentially then it's quite widely and quite broadly applicable. It's applicable to incorporated companies, so typically your professional services environment, attorneys, auditors, that type of thing. Private companies, your traditional closely held companies, public companies, your limiteds there, state-owned companies, as well as non-profit companies. So essentially the only exclusion that we have is closed corporations. Closed corporations need not comply with the CIPC Compliance Checklist requirement. But again, I just need to stress is, as per my previous comment, CIPC has indicated it's not going to focus on just larger or listed entities. They're going to look at entities across the board. So that includes privately or closely held companies, typically your PTY limiteds. And that's typically where we've seen that there has at times been not so much of a focus on compliance. So it's there that really the boards are going to have to try and up their game. Getting to what sections are included, and I'd like to start here with just a general comment before we dive in. Firstly, it's worth noting that viewing the listed sections in this CIPC compliant checklist in isolation will not work. Each section requires detailed knowledge of the sections that interlink with that particular compliance question in order to provide a well-considered answer. Unfortunately, there's not enough time today to deal with all of the details in all of these sections. We only have 30 minutes, so we'll stick with a brief overview of what's included in the list today. But we do hope to do some more webinars in future on this particular item, and hopefully then we can kind of break up these sections into almost like a bite-size session where we can deal with the details and the considerations that you really need to think about when dealing with these, answering these questions. So what's included? Your first question on the list would be, did you comply with Section 4 in the calendar year? Now we know Section 4 refers to the solvency and liquidity test, and essentially that tells you how to apply the solvency and liquidity test. We'll deal with Section 4 as an example later, where we'll dive into some of the detail there, and when you see exactly how complex this becomes. Section 15 is the second one then. Now that deals with your memorandum of incorporation, your shareholders agreements, as well as the rules of the company. Rules, they're referring to rules adopted by the board. It's more than just an informal set of rules. It could address anything that's not dealt with in the Act or the MLI, but there's a very particular process that you have to follow in terms of Section 15, in terms of adopting those rules as well as submitting it to CIPC. So when you answer Section 15, you have to make sure and you have to consider whether there's been any amendments to your MLI, whether these amendments has followed the correct procedure in terms of having the MLI amendment attended to. You have to know the alterable and unalterable provisions of the Act really well, and you have to know how your MLI deals with the alterable provisions in order to answer Section 15 in a well-considered manner. Furthermore, I would suggest that any shareholders agreements that are still drafted in terms of the 1973 Act would definitely have to be updated in order to tick yes, we comply with Section 15. And then, of course, you'd have to consider whether your board has adopted rules and whether it's followed the right process in getting those rules in place. Next section is Section 26. It essentially deals with when does a shareholder or a third party have the right to access your company records, and indeed in certain instances have the right to copy the records of your company records. Quite a lot of detail in that section, quite a lot to go through. Then, of course, Section 27, a change in company year-end, also included in the compliance section. Again, a lot of process-driven items that you have to make sure was attended to before you can say, yes, we complied. Section 28 and Section 29 included, that relates to your financial statements and annual financial statements. Again, with your accounting records in terms of Section 28, you have to make sure that your accounting records are indeed up to date, that they're kept at your registered office, and you have to make sure that you deal with all of those onerous requirements. Section 32, the use of your company name. Questions you have to ask there is, am I using my company name in the correct manner? Is it clearly legible on all of my printed material, etc., etc. Section 33, as regards to your annual return, also included in the CIPC Compliance Checklist. And then getting to some of the very meaty sections in the Companies Act. And there I'll take a little bit more time, if time allows, just to explain one or two things. Section 44, financial assistance for acquisition of securities in the company, and Section 45 also included in the CIPC Compliance Checklist. In dealing with Section 45 particularly, this is one of the sections where, when the question is posed, did you comply with Section 45 during the calendar year, I can foresee that some companies will fall foul of saying they complied when actually they didn't. Generally, when you consult with clients, they know of 3 requirements in terms of Section 45. They know that you have to have a special resolution authorizing the loans or financial assistance to directors and group companies, and they all know that that is valid for 2 years. They'll know that you have to have a director's resolution in place, and they'll know that you have to, in the director's resolution, be seen to be applying the solvency and liquidity test. And if they have those 3 things in place, they'll say, yes, certainly we complied with Section 45 in providing this loan to a group company or to a director. However, those are not the only requirements in Section 45. A requirement that not many clients know of is found in Section 45 sub 5 of the Act. And that says that if you have a loan to a director or a group company, and you've gone through the process, you must also provide written notice of that resolution to all your shareholders, unless every shareholder is also a director of the company, and to any trade union representing the employees of the company. And then it gives you a timeline to do that in, a choice between 2. If it is a loan, or your aggregate number of loans exceeds 1/10 of 1% of the company's net worth, you must notify the shareholders and the trade union within 10 days after the board adopts the resolution, or B, within 30 business days of the financial year of the company, at the end of the financial year, in any other case. Now, that's a requirement that I have not seen being adhered to a lot when consulting with clients. And definitely something that you cannot tick that you comply with Section 45 if you haven't attended to that. So very easy then to provide an incorrect answer there. Similarly, so in terms of Section 50, when it comes to a securities register, it would be very tempting to say, oh, of course, we have a share register, and I'm sure it's fine. We can tick we comply with Section 50. However, there's a lot of detail in Section 50 relating to the names and addresses of shareholders, how your numbering of share certificates should be attended to, whether you are listing beneficial interests of beneficial holders correctly. Are you dealing correctly with different classes of shares in your share register? So again, not as simple as merely saying, yes, of course we comply. Again, also in Section 61, which is included in the CIPC Compliance Checklist. Their companies, especially that have not updated their MOIs, that still have an MOI in terms of the 1973 Act, need to be quite careful when they answer whether they've attended to shareholders' meetings in the correct manner. The reason for this is that the new Act says an AGM would only be applicable to a public company. However, in many of the 1973 MOIs, you would still find a reference to an AGM that has to be held for a private company. And if that requirement is still there, that company must comply with Section 61, sub 7 and sub 8 of the Act. Now, that requires quite specific things that must be covered in your AGM. Particularly subsection 8 of Section 61 says, at a very minimum, you have to attend to the presentation of the director's report, the audited financial statements, an audit committee report. You have to attend to the election of directors as per the Act or the company's MOI, and you have to attend to the appointment of the auditor for the current financial year and the audit committee, as well as any matters raised by shareholders with or without advance notice to the company. So very specific in what you have to deal with in terms of Section 61, not really as simple as just saying yes, no, or not applicable. Again, section 66, you have to make sure that your board is properly constituted. In other words, do you have at least 50% of your directors elected by your shareholders? Also, section 69, in eligibility and disqualification of persons to be a director. This is another place that I foresee can be tricky to answer, because a lot of companies would be tempted to say, of course, we have rigorous processes in place to ensure that our directors are not ineligible or disqualified when we appoint them to the board, and we monitor it quite often. However, what people do tend to forget is that section 69 also applies to prescribed officers. And in many instances, when you consult with clients, quite often they're not aware of who the prescribed officers within their business actually is. And if you haven't gone through the process of actually identifying your prescribed officers, how would you even know whether, for instance, they are an unrehabilitated insolvent, or whether they have been removed from a position of trust, and on all of those sort of ineligibility requirements? You wouldn't have had the opportunity to properly investigate it, because you wouldn't even have identified them in the first place. So be very careful in terms of just accepting that you comply with these sections at face value. There's quite a bit of consideration that has to go into it. In terms of section 70, vacancies on the board, quite a lot of requirements there. Section 71, removal of directors. This is one that I think many lawyers are very afraid of, because section 71 is quite tricky. If you are going to be using section 71 to remove a director from your board, you'll see that the process described by the Act in section 71 is akin to a lot of sort of the laws of natural justice and the administrative justice provisions. And it's a very, very detailed process. So if you do use that section within a particular calendar year, and then you are called upon to say whether you complied with section 71 or not in doing so, you have to make sure that you applied that process to the letter of the law, and you stuck to that procedure really, really well before you can confidently say, yes, we complied. Then section 86, mandatory appointment of company secretary, also included. Section 90, appointment of auditor. Again, a section that I think would be tricky. It would be easy to say that, yes, of course, we appointed our auditor, we did the proper resolutions, everything is in place. But very important to look at section 90 sub 2 sub B, which is the restricted services of auditors to ensure their independence. You have to make sure that what's actually happening, the services that your auditor is actually rendering, is in line with what's required in section 90 sub 2 sub B, before you can confidently answer that question and say you comply. Rotation of auditors, section 92 included. Section 94, audit committees. Again, if you have an audit committee, very important to consider the detail regarding how this committee should be constituted before answering that question on the CIPC Compliance Checklist. In other words, you have to really look at who are the members sitting on your committee, as opposed to what the Act requires. Are they truly non-executive directors? Are they sufficiently removed from the day-to-day running of the business? Are they, for instance, material suppliers to your company? Because if so, there might be reason to challenge their independence and their the fact that whether they're truly non-executive or not. You quite often see where attorneys might sit on the audit committee or be appointed there, and in truth they would probably be a material supplier, or could be a material supplier, depending. Then getting to the regulations as well, Regulation 21 relating to your registered office. Regulation 43, also included in the CIPC Compliance Checklist, relating to social ethics committees. That's another one that can be quite tricky in terms of detail, particularly if you have one committee for an entire group of companies. You will quite often see that it would be quite tempting for a company to then say, yes, of course, we have a committee, we have a couple of group companies, we have a committee constituted in one of our entities, and it serves the function for the entire group. Of course, we then comply with Regulation 43, but it might not be that simple. You actually have to go and look at the charter of that social and ethics committee, the terms of reference in terms of which it's constituted, must expressly state that it binds all of the companies in the group. If it's not that express, you actually do not comply with Regulation 43. And then, of course, Schedule 1 relating to all of the provisions relating to non-profit companies, also very tricky, quite a lot of detail in there. So from looking at the list and everything that's included there, it already seems quite onerous, but I'm afraid it's even more complex than that. And looking at what is actually required and what you need to do to answer these questions, it becomes very clear that we can't look at the sections in isolation. We have to look at all the linking sections to each of these requirements and that interact with the questions posed by the CIPC Compliance Checklist. And here I'm going to use Section 4, the Solvency and Liquidity Test, as an example. As we know, Section 4 is the relevant section here. And really, Section 4, 1A and B tells us how we have to apply the Solvency and Liquidity Test. It tells us we have to look at the assets of the company as fairly valued and that they have to equal or exceed the liabilities of the company as fairly valued. It also tells us then in subsection B that it has to appear that the company will be able to pay its debts as they become due in the ordinary course of business for 12 months after the date on which the test is considered, or in the case of a distribution, 12 months following that distribution. Subsection 2 then tells you what you need to consider to apply the Solvency and Liquidity Test. Your accounting records as per Section 28, financial statements, you have to consider the method or the methodology surrounding the valuation, etc., etc. So it would be very easy to say, well, yeah, of course, we comply with Section 4, but we can't just stop there. We have to actually look at what interlinks with Section 4. And there would typically be then a number of sections in general that experts would tell you link in to Section 4. And there we start with Section 46, which is your normal distributions section. You have to look at that section. Usually a very general part of it would be a dividend. So let's say there was a dividend paid in the calendar year that you are answering this compliance question to. You have to actually look, was there a dividend declared? Was the right procedure followed in declaring the dividend? Was the Solvency and Liquidity Test applied? And you have to make sure that the board didn't just pay lip service to the Solvency and Liquidity Test. So ideally, one would want to see some form of calculation, or could be perhaps annexed to the resolution to prove or to support the passing of the Solvency and Liquidity Test. But also, you have to look at whether payment in terms of that declaration was actually made within 120 business days. If it was not, was there a retested Solvency and Liquidity? Because if it's not paid within 120 business days, you have to retest for Solvency and Liquidity. You can't just make payment. So very clear to see there that without properly considering Section 46, you can't actually answer the question as to whether you comply with Section 4. Similarly so in Section 44, Financial Assistance for Securities, you have to look at Section 44, sub 3, sub B to see whether those requirements have been adhered to. Similarly, Section 45, you have to look at Section 45, sub 3, sub B to determine whether those requirements have been adhered to. Again, in terms of Section 47, capitalization shares, if there was an event where capitalization shares were issued to shareholders with a cash payment alternative, there's a very particular manner in which you have to apply the Solvency and Liquidity Test. So if there was a cash alternative, the board must consider the Solvency and Liquidity Test on the assumption that every shareholder would have elected to receive the cash instead of the capitalization shares. So a very particular manner in which you should apply it in that instance. You also have to look at Section 48, buybacks. You have to look at Section 113, amalgamations and mergers. If there was an amalgamation or a merger, did each amalgamated or merged entity comply with the Solvency and Liquidity Test? And that would be your general sections that would interact with Section 4. But there was an additional one that I thought of that, granted, it's fairly limited in its application. It deals only with domesticated companies. What a domesticated company is generally it's a foreign company that actually re-domiciles and registers them in terms of South African law. But if you are dealing with a domesticated company, Section 13 sub 6 sub F of the Companies Act says that domesticated company must pass the solvency and liquidity test immediately after the transfer of its registration. So again, just goes to show how much detail is involved in actually just answering the first question, do you comply with Section 4? So very clear to see that you have to have an in-depth knowledge of the Act and of the transactions of the company in order to answer these questions in a well-considered manner. But it's even more than that. You have to make sure that you're able to evidence your answers. This is not required in terms of the form. The form just requires you to say yes, no, or not applicable. But CIPC, if you are one of the companies that are monitored and being looked at, might require you to provide evidence in that regard. And then it's not enough to say that you don't have the evidence, but you ticked yes, you comply. So what's needed, what's actually required from our point of view? Intimate knowledge of the transactions and events that took place in the calendar year. We saw that with the Section 4 example. You have to know your legal requirements. You have to know your Act. You have to know how that's applied in your MRI, your shareholders agreement. You have to know whether the board passed any rules. And then once you know what happened and you've applied your law, you have to make sure that you had the authority to say that, yes, we complied with these sections. Did you have your directors' resolutions and shareholders' resolutions? And do you have them on file? And I would suggest that it's essential then to have a working papers section. You have to have necessary evidence to support whether you complied or not. And there we would be looking at registers, records, financial statements. In the case of the solvency and liquidity test, I would suggest calculations would be important. And then probably for me, the most important part is the declaration to be signed by a director of the company for each of these sections must also be included. This is very important in order to evidence the interpretation followed by the company in the particular compliance section of a section. Any good lawyer will tell you that two people can view the exact same wording and interpret it very, very differently. Therefore, this declaration signed by the director must state the facts, it must state the law that was applied, and it must be very clear on the interpretation of the law that was applied, and then must be signed and dated by a director. So as you can see, a lot to do, a lot more than just merely ticking a tick box. Looking at the risks and consequences, I know we are starting to run a bit short on time, so I'm going to try and go through it quickly. Firstly, in terms of risks, there would be two items there. Firstly would be incorrect information presented to CIPC unintentionally. There, CIPC has indicated you can send an email to that provided email address on our slide, and you would have to explain why the incorrect information was submitted. So in other words, what happened? What was my thinking behind submitting the incorrect information? And then you have to also motivate why it should be rectified. CIPC will then consider this information provided, and they will make a determination, and from that will follow some form of rectifying action. It might be a compliance notice or whatever it might be that CIPC decides is appropriate in the circumstances. The more serious one would be intentional misrepresentations. And there's quite a bit of confusion as well as to what the actual penalties are. CIPC is of the view that if you intentionally provide false information to CIPC, you would be found guilty of an offence, and it would lead to imprisonment not exceeding 12 months, or a fine, or it could be both a fine and imprisonment. And they base this view on Section 215 sub 2 sub E of the Companies Act, which says that if you knowingly provide false information to the commission, the tribunal, and there's one or two other additional bodies, you would be guilty of an offence. And the penalty linking to that offence would be Section 216B of the Companies Act, which states that you could be provided with imprisonment not exceeding 12 months or a fine or both. Industry experts, however, have said that you have to look at Section 214 of the Companies Act, which says that a person would be guilty of an offence if they are party to a falsification, knowingly and fraudulently providing false or misleading information to a person in terms of the Act. That would then lead to a penalty under Section 216A of the Act, which would be imprisonment of up to 10 years or a fine, or both. So quite a bit of confusion there. 10 years is a substantially longer period than 12 months. However, if you ask me, for an average Joe on the street, even a week is too long to be imprisoned. But in this regard, I think CIPC is probably correct. Section 215 sub 2 sub E deals specifically with intentionally providing false information or knowingly providing false information to CIPC. And therefore, I think that would be the correct clause to apply. So I do think it is limited there to the 12-month period, or a fine, or both a fine and imprisonment. Lastly, then, just looking at current uncertainties. And here, particularly then looking at the SA Institute of Chartered Accountants, CIPC, having highlighted some issues that they foresee with the CIPC Compliance Checklist. Essentially, what CIPC has said is that given that we are entering an age where data privacy is essential and where it's very important to know what will happen to information that you provide, they have questioned what CIPC will do with the information provided. What they've also called CIPC out on is how they will deal with the differences in interpretation of the Companies Act. As we said, it's something that's bound to happen. What CIPC has said and what their suggestion was with dealing with these differences in interpretation is very similar to our view on it. It's really to document how you interpreted the section and to make sure that you're able to evidence your interpretation of the section. Then another item raised is this usage of the term calendar year. A calendar year is not defined in the Companies Act 71 of 2008. So in other words, when does it start running from? Does it start running from 1 January to 31 December? Or do you look at the incorporation date of a company? Does it run from the first day of the month within the incorporation date and 12 months thereafter? There's no clarity in this regard. So we don't know exactly what CIPC is referring to. There are rumors in the industry that CIPC has taken some of the processes in the CIPC Compliance Checklist into consideration. However, there's been no word from CIPC yet in that regard, and we can't confirm it as yet. And really, those are the sort of highlighted uncertainties currently. And it's at this point where I think we have come to the end. It has been a very brief overview, but it should give you an idea as to what's required. I will take questions. You can submit them electronically, and I will then revert to them in due course. So with that, I'd like to thank you for your time and attention, and I'd like to wish you a good Friday and a happy weekend. Thank you very much.